Hello, everyone. Thanks for taking the time to meet today. Some of you may have been present at the webinar done toward the end of last year, where I spoke about different methods for how to get to an agreement. And I talked about the one-on-one method, where the parties communicate directly and bring the lawyers in to do the drafting. I talked about the lawyer-to-lawyer method, where each client hires an attorney and they do the talking, negotiating, and drafting. And I mentioned the mediation model. And that's what we're going to talk about right now, is the mediation model. And let's start with, we're going to go through an overview, the role of the mediator, the role of the parties, and completing the mediation. So let's go to the next slide. What is divorce mediation? It is a form of what we call alternative dispute resolution. There is arbitration that a lot of people who are engaged in employment type conflict resolution or involved with unions. We hear of, we hear of arbitration, binding arbitration, things of that nature. That's a form of alternative dispute resolution. So mediation is the same. Mediation in the realm of matrimonial, custody, negotiating is not in and of itself binding, which is wonderful, because it gives the parties time to reach a resolution without deadlines hanging over them, or if they walk out one day having agreed to an item, they can't go back at the next session and still bargain and negotiate. So in the case of a divorce, it's a methodology for settlement to avoid what we call a contested divorce. And a contested divorce isn't just my spouse served me with a complaint for divorce. A divorce isn't actually contested until the parties opt to get a judge involved because there are certain issues or roadblocks they can no longer get beyond, whether negotiating one-on-one through lawyers or with mediation. So even if a case is sued, we don't consider it contested unless we have to get a judge assigned to intervene. And it's best to keep a case out of being contested if at all possible, because it keeps the control in the hands of the parties. The parties can do a lot more in an agreement than a judge can do. And there's a saying that a judge, if you give a case to a judge, he or she has to use a hatchet to decide the issues. Whereas if parties can communicate, negotiate, they can do it with a scalpel. They can carve out very unique things that are necessary for them that a judge doesn't have the authority to do, or doesn't have the time or the knowledge of the intricacies and the nuances to be able to do. A lot of people come out of a contested divorce where a judge makes a decision, and a judge may do a wonderful job, but there are always details and nuances that the parties can't have addressed by a judge and still need to handle. So staying out of a contested divorce is wonderful. I tell all my clients, if you litigate, who's the winner? The winner are the lawyers, because you pay us, and that's not always in your best interest. So mediation, we try to stay out of court. We try to avoid having to get a judge involved, and the parties try to treat each other as non-adversaries, as just co-interested parties looking to problem solve. Think of it as a problem-solving mechanism, because the reality is most marriages or relationships that are ending are really not battles to fight, but problems to solve. So the hope is it is a softer, less stressful, more cooperative approach, individualized, as I said, in resolving the issues. And while lawyers are necessary, and we'll talk about that, we're going to keep the lawyers' involvement to the sidelines. It is voluntary, but courts very much like mediation. Before COVID, I'd say toward the end of 2000, sometimes in 2018, the courts, at least in the upstate New York area around the capital region, were beginning to explore court-supported, system-supported mediation. And they were having meetings with attorneys and different organizations to talk about putting training into effect because the hope was that they would have a lot more mediators available, and the courts themselves, when a case even did come in front of a judge, would then have mediation services available to send the parties to. So it is absolutely something that may pop back up once everyone gets back on track, as we are doing. But there are private mediators out there that are available. And I can offline after this seminar, if anybody wants some potential references, let me know. Family courts, again, in the Capital Region, particularly Schenectady County, I know, was using mediators a lot. And they had some very good mediators there, and it was at no cost to the family court parties, which was nice. Whether or not that's going to be the case when the courts get more involved, I don't know. So how is mediation different? Next slide, please. This is just going to be a quick comparison between the difference if you're contesting versus mediating. The spouses are opposing parties. So right away, litigation puts everybody in a very defensive posture just from the very beginning. Even with no fault divorce, where nobody's pointing the finger at the other party for cheating or abusing or abandoning, there is still a plaintiff and a defendant, and that still sets up a dynamic of somebody against somebody. And so just psychologically, that has an effect. Whereas in mediation, it's two people, whether spouses or parents of a child dealing with a custody issue, who are in conflict that want to mutually reach a resolution. They're both invested in the process. Contested litigation, each party takes the most aggressive stance. If they don't, their lawyers typically do. The lawyers work for you. If you don't want them to be aggressive on a certain issue, they should not be. Their job is not just to advocate for you, but to counsel you. But you do have them taking aggressive positions. I tell attorneys that if you're going into court and you want to win, you have to be ready to do battle. So automatically you're setting up your lawyer to be more aggressive, even subconsciously. Whereas in mediation, the parties are collaborating to work toward a common goal to resolve their issues together as opposed to battle them. In contested litigation, this can lead to a high stakes, all or nothing demand mentality. Whereas in mediation, it's looked at as a win-win scenario, and more creative ways are explored to try and find out what motivates each party, what are each party's primary goals, and to find a way to bring them together. In litigation, control over the case and the language is in the hands of the judge and the legal system. You have to deal with burdens of proof. Discovery, again, it's more expensive, it's more drawn out, and the judge who has to ultimately make the decision is boxed in by the law and what the law will allow that judge to do. Parties in mediation can create the space, the language, the solutions that work for them. They can barter things back and forth that a judge can't do. And you may say, why can we agree to something, but a judge can't do it? The judge is limited by case and statutory law. So for example, if two people can't agree on, there's a pension, the wife has a pension, she wants to keep it. The husband wants the house, the husband wants to keep it. In settlement, they can get these things valued and decide if they want to trade them off. In court, a judge is much more limited. A judge can't necessarily say, you keep the pension, you keep the house. A judge may be in a position to have to say, sell the house, split the money, split the pension. And that may not be in everybody's best interest. So it's just a general illustration. In contested divorce, there's greater risk of permanent resentment to the other spouse, and that can also damage the relationship between the parties, which spills over ultimately, even if you try not to, onto the children if there are any. I try to caution couples that even if you don't get along right now, if you have a child or children in common, think about the day when that child has to be walked down the aisle for a wedding or graduates, or there's a celebration, and what your poor son or daughter are going to have to go through doing a seating chart at a reception. So you want to try and keep the relationship at least cordial, if at all possible. And the contested litigation, people are going to get on the witness stand, and say things that, you know, maybe they don't really want to say, but they have to say in order to convince a judge. Once you say something, it can't be taken back. It's said in a setting, a courtroom, and that's really hard to undo. Whereas in mediation, again, we're going to keep the lawyer's involvement to a minimum, which I'll explain. Another reason to consider mediation is I find that you can always escalate a problem. It's hard to de-escalate a problem. If mediation doesn't work, the courts are there. You can always go and litigate. That's not a problem. But if you start with litigating and there is an adversarial stance, it is often very hard to back up halfway, 2/3 of the way through the process, and now say, oh, okay, we're going to get along and sit down and mediate. I'm not saying it's impossible. It's just much more difficult. So should everyone mediate? People come to the idea of mediation one of two ways. Either they do a consult with an attorney, and that attorney puts mediation out there as an option. And 99% of the time, when I consult with somebody, I give them the mediation option. Not just hire me, but there is this other way to go. Not every attorney does that. Some do, some do not. Some don't like mediation for whatever reason and may not even recommend it. So you may come to the idea after having consulted with a lawyer who says, let's look at this as an option, or it's become much more popular. We're doing this webinar. You talk to someone at your barber who said, hey, you know, my divorce went through mediation. But should everybody mediate? The answer is no, not everybody. Mediation, as you see in this slide, it can be a lower cost, a more efficient and less stressful process than traditional divorce litigation, and couples can benefit from it rather than going straight to court. But I do not recommend it in cases where there is domestic violence, history of domestic violence, physical or safety, intimidation. Even if there's not been an order of protection, if there is that physical intimidation or fear, a lot of mediators won't take the case if they get wind of that going on, or if there is an order of protection. And in fact, if there is an order of protection in place and it's a stay away order of protection, you cannot both go and sit with a mediator or necessarily even talk and do a Zoom session with a mediator, because that could put you in violation of the order of protection. So where there's an order of protection, or there's been a history of domestic violence, where there is a significant lack of trust, either whether it be financial trust or just trust in what the other person is going to represent, that is not a good idea to attend mediation. Or if there is an imbalance of bargaining power, not just a trust issue, but an imbalance of bargaining power, either because there's a lack of knowledge of marital assets, values, et cetera, on one side, but there is emotional or psychological imbalance of power. One party is much more overpowering emotionally than the other. The mediator can do certain things to help balance that power, but they can't get beyond the psychological issues. An imbalance in financial knowledge, asset knowledge, is not necessarily a reason not to do mediation, though, because I'll talk a little bit more about it as we go along, but there is a requirement to produce financial data for the mediator so that the process can take place. But this is a trust situation. The mediator is not going to dig deep to find assets or bank accounts or do a financial analysis to find out if somebody's been doing something wrong with the family funds. So you're going in there with a sense of trust and respect for each other and somewhat of a balance of power. Why mediate? I think we've covered some of the issues here so far. Financial cost. Somebody actually had pre-sent a question on this, so I'll address it right now. What's the cost differential? Given the fact that lawyers charge by the hour and most mediators charge by the hour, just think of it, if you hire a lawyer and pay that lawyer by the hour, $300-400 an hour, and your spouse or the other party hires a lawyer paying $300 or $400 an hour, every conversation that the lawyers have is costing $600 to $800 an hour, because you've got to call your lawyer, who then calls the other lawyer, who then calls their client, back and forth and back and forth. In mediation, think of a triangle. The mediator is at the top, the parties are at the left and right lower corners. If the mediator charges, again, hypothetically, $300 to $400 an hour, and the parties are doing it together, they're sharing that cost. So each party is investing half the cost of the mediator for the hour. There will be additional costs as you consult with the attorneys on the sidelines, which we'll talk about. But overall, it tends to be a more efficient, cost-effective model. Emotional cost, again, we talked about that already. The emotional cost of litigation and having to go through putting your entire lives and finances and little issues in front of courts and attorneys, versus just focusing on what are the issues and how do we want to resolve them? What are we going to do with the house? What are we going to do with the kids? How do we pay support? How do we split the retirement accounts? How do we settle the debt? Time cost, again, if people can sit down together, whether you do it with a mediator or there's a model that those of us that have been around a while, especially pre-COVID, really like, and that is settlement, where the lawyers and the attorneys get in the room together and talk. So whether it's a sit down with all parties and lawyers or a sit down with a mediator, that is much more time effective also, because you're having, real-time discussions about issues rather than waiting for somebody to return a phone call, return an email, provide a document, etc. Control over the process, we've already talked about. The parties control the time and the process. And it is a confidential first step. If mediation does not work out, it cannot be used against either party. Most mediators have the parties, when they retain, sign a confidentiality clause in the retainer saying, we acknowledge that if mediation does not work, this mediator will not be called upon by either attorney or able to testify in court as to what we discussed. And the courts won't hold it against you if mediation didn't work. They often appreciate that the parties tried. All right, the mediation process. How does one get there and find a mediator? As I already mentioned, you will either, after having done initial consult with an attorney, made the decision that either you want to try mediation or you don't, for whatever reason, you want to go through attorneys or through the courts. So that one way you find. The other way is through a webinar like this, where you learn it even exists. You Google. Let me tell you a little bit about finding a mediator. And my exposure to mediators is limited pretty much to the capital region. So you probably have to look in your area, because some people on this webinar may not be local. But check their qualifications. There is no, as far as I know yet, and I was talking with a very good mediator a few weeks ago, they've been talking about coming up with certain certification and qualifications for mediators. Don't believe that's been done yet. So anybody can hang out a shingle and say they're a mediator. You can take a 4-hour course. Years ago, 30 years ago, I took a 2-day course on mediation. That's not enough training. That's just the bare bones. You want to make sure that the qualifications of the mediator, that they've had extensive training. You want to make sure that they are knowledgeable in the family and matrimonial law arena that you're talking about. That doesn't mean they have to be an attorney. As I said, the mediator cannot give legal advice. If a mediator does, then they're not doing their job right. They cannot give legal advice, but they should know the area of law, because what a good mediator will do is, if they see during a session one of the parties is getting into a dangerous area, hypothetically, a spouse doesn't know that they have rights to an interest in their partner's pension. They don't know that. They've never talked to a lawyer. They have no knowledge of that. And they're getting ready to sign away their rights to half a pension that is accumulated over a 30-year marriage. The mediator can't stop and say, hey, you have rights to that pension under Majauskis versus Majauskis, and here's how it works. No, but the mediator should flag the parties and say, look, I have some concerns regarding the discussion over the pension. I recommend you both go seek attorneys and talk to them before we come back again. so they can flag issues. And that's really important. If the attorney has no knowledge in the field, then they don't know what issues to flag. If you ask me, you tell me you're having heart palpitations, it means nothing to me. I don't know what to flag. I'm not a cardiologist. So keep that in mind. Also, have some further knowledge of what the mediator is going to do for you. I will touch on this briefly. There are some most mediators will simply mediate, meaning they will help the parties come to the broad strokes of the agreement, but they will then send the parties to consult with an attorney. One will draft it and the other side can have an attorney review it or can sign it without a lawyer. But the attorney will not draft the final agreement. The attorney will put together what I call the Reader's Digest version. And if you were born after 1990, you probably don't know what Reader's Digest is, but it's condensed. And that's what some of the best mediators do, because they realize that actually drafting the document is an advocacy process. I'll talk a little bit more about that as we get into the lawyer's role. But there are mediators out there who will actually prepare the agreement. And then they just recommend the parties have lawyers review it. There are even some mediators out there who will go the final step and actually do the mediation, draft the agreement, and represent one of the couple in an actual divorce, in filing a divorce complaint and all the papers necessary to turn that agreement into a final judgment of divorce. That's someone that does everything. I would again, I'm not just being protective of what lawyers do, but I really think, in my experience, the mediator should only draw up the memorandum, the terms that have been agreed to in the general terms, and then let the lawyer step in and do the advocacy of the drafting. The actual filing of the divorce at the end of having the agreement signed is just simple and inexpensive in any event. So how does one find a mediator? Again, with Google or going online, you can find anything these days. Ask a friend, call a lawyer, consult with an attorney, but do look into their qualifications. That is key. All right, so how does the process work? Couples tend to meet with a mediator over a series of sessions. One of the mediators I like to use addresses the children first. If there are children in the marriage, I think that is a very good approach for two reasons. One is it usually brings the people together over what means the most to them. You can sell a house, you can split a pension, but you can't cut the baby in half, as they say. So it's something that both parties usually have very deep buy-in to, number one. And number two, if you cannot resolve the issues concerning custody, you may not want to go forward on mediating everything else, because you're still going to have that big problem hanging out there. But not all mediators do it that way. But the point is they break it down. Okay, guys, next week we're going to meet and we're going to talk about the cash accounts, the financial investments. So make sure that you have updated statements on your bank accounts, your CDs, your mutual funds, your retirement accounts. And the session will focus on that. All right, we've got a tentative resolution on those issues. In 2 weeks, we're going to come back and talk about the house. So do we need an appraisal on the house? Do we need to know, is there a mortgage? How much is owed? How much is it a month? Maybe the parties have to look into, can somebody refinance it? We're going to talk about, does it get sold? Does the wife keep it? Does the husband keep it? Is there exclusive occupancy and sale in the future? How do we refinance the mortgage? Can you afford the mortgage? So it's broken down into sections. Where I'm going to skip to the very last question and then go back to the middle. But on this slide, the last statement says, where does the lawyer fit in? The lawyer should fit in, if you remember that triangle. The lawyer should fit in as coach on the sidelines. So as you go through these sessions, when clients hire me and I recommend mediation, or they started mediation and they want an attorney, I always say, when's your next session and what are the topics? Okay, Barb, next session, we're talking about the house. And then I have the client get me information I need so I can do a conference with the client on the phone or in the office and say, okay, here's the scenario, here's your options, what do you want to accomplish? And we come up with a game plan so that when the client goes into the mediation session, they're informed on the law, they're knowledgeable as to their options, and they have actually worked out some practical game plans. We've looked into what are the refinance rates and can you afford that mortgage? We've looked into if you were to sell it, what are the problems with the house that you have to fix first? Are there any issues on getting another suitable home to go to? What's your budget? Can you afford to maintain the home? So they're going in with a full picture, because the mediator is not going to sit there and say, okay, Mrs. Smith, you're going to keep the home. The mediator is not going to say, have you thought about if you can afford the insurance? That's not their job. Their job is much broader stroked. And then the client will come back and say, okay, we resolved this. And Barb, next week, we're going to talk about child support. Okay, now I'm going to take the time before the next session to educate that client on the child support statute, on the deviation factors, on the add-ons, issues like health insurance coverage. Do we need life insurance to secure the child support? Can it be modified? Under what terms? Do we want to waive the modification in the future? Do we want to lock it in? Again, details that a mediator cannot and will not, and actually should not, be going into with the parties. So it's very important that you, if you're going to go through the process, even if you haven't met with an attorney before you started mediation, early in the process, get an attorney on board. If the client says, Barb, next week we're splitting the furniture, I don't need to talk to you about that. That's fine. I'm not going to get involved in how you split your Tupperware. It doesn't matter to me. If there's very little need, you use the lawyer very little. What you don't want to do is go through half a dozen or 8 sessions with a mediator, have the mediator produce a memorandum, and then you take it to a lawyer, or the other side has their attorney draft it, and then you take it to a lawyer. And I get a hold of it and say, oh my goodness, do you realize you're never going to get more child support in the next 20 years? The amount you've agreed to is all you're ever going to get. Do you realize that you're walking away from a pension that could secure your future when you have none? Now they have to go back to mediation either and unravel the whole thing, which is psychologically hard because the other side is now annoyed that they went through the whole process. They got an attorney to draw up an agreement, and now it has to be redone all over again, either through mediation or the matter becomes now contested and aggressive and adversarial. And you're bringing lawyers in to redo, or the courts in to redo what wasn't done properly in the first place. So I know cost cutting is on everyone's mind, but the most intelligent thing to do is get the advice along the way. If a client says to me, I know I'm entitled to half the pension, but I don't want it, or I'm taking something in place of it, even if it's not of equal value. Lawyers' jobs are not to prevent people from doing what they want to do. Lawyers' jobs are to make sure that the client is fully advised, knows with open eyes what they're doing, what the consequences are. If in the end, that's what they want to do, it's their money, it's their home, it's their kids, it's their future. The lawyer might have you sign a statement saying I was advised, but the lawyer's job is not to prevent a resolution. So some people are afraid if I get a lawyer involved, it'll become adversarial. If you're consulting and getting a good feel for the lawyer and their willingness and that they like to and have experience working with mediation, you shouldn't run into that problem. Okay, back to the list. Financials are exchanged or disclosed. Again, we are trusting each side to be producing this. This is where having a lawyer look over the financials along the way is helpful. If I see a marriage of 20 years, no kids, they both work full-time, making decent incomes, they live in a middle-income neighborhood, and yet they have a lot of debt or no savings, I'm going to start prodding my client to say what happened. And if the client says, I have no idea why we're in debt and have no savings, then, the spider senses are going to tingle and we may want to look at some more things. Or it could be, you know, my mother-in-law had a bad medical condition and she was a widow and we helped her through it. And so we used our savings. I hear those stories. So some things will make sense or not, but it has to pass the smell test. And it helps to have an attorney at least look at that peripherally for you. And sometimes the attorney may say, this smells really, really bad. And if we're not getting honest information through the mediation process, what are your options? Okay, mediator acts as a guide and facilitates the discussion. It's the parties who make the decisions, hopefully with good counsel and guidance. Sessions continue until all issues are resolved. That's not completely accurate in that all issues may not get resolved. Mediation is not 100% successful. If you use a good mediator, I would say it's at least 80% successful. Could even be closer to 90%. But if you're doing 6, 7, 8 sessions and nothing's getting resolved, pull the plug. Something's going on. You're not getting anywhere. Talk to an attorney and find out what's going on. Consult with your attorney. If issues cannot be resolved, as I said, you can always escalate to you each go out and hire lawyers or somebody starts an action for divorce. Next, an agreement or a memorandum is prepared. Let me caution you on something. Over the last 2 months, actually over the last year, there's been more. I've gotten 3 cases and heard of a 4th, but there are 3 clients I'm actively representing who went to a mediation outfit. I don't even remember who they were, but it was not a experienced divorce mediator, who they reached terms of agreement with. The mediator drew up the agreement and they signed it. And then when the parties went to get a divorce, to turn that agreement into a divorce, the judges are refusing to accept the mediated agreements. And that is because these particular outfits that are doing it are either not lawyers or not qualified in the field, and they're not drafting the agreements thoroughly enough, or they're just having the parties sign the memorandum itself. And there's gobs and gobs of information that is missing. The courts are very, very strict on making sure that these agreements are thorough and fair. In particular, if there are children and there is an issue of child support, if the Child Support Standards Act is not followed step by step by step with all the calculations, all the acknowledgments, all the disclosures, all the waivers, court's not going to accept it. And the courts are getting picky also when they get agreements that talk about real estate, but the terms are not complete or thorough. It says the wife will get the house, but it doesn't say anything about the mortgage or who pays what. So do not just sign a memorandum. But if a mediator prepares a memorandum, have that turned into a full agreement. All right. Issues discussed. No fault divorce. Again, we have this irreconcilable differences grounds in New York since 2010. Simply have to say one party has to sign a complaint that the marital relationship has broken down for at least 6 months. That's it. No blame other than that. But you cannot get that no fault divorce unless you have a signed agreement in place that resolves all the issues. In other words, the judge will simply sign your divorce judgment if you present the court with that fully properly executed and fully spelt out agreement that resolves all the issues: debt, tax deductions, everything. Length of mediation sessions usually run 1 to 2 hours. It can be exhausting. So, make sure you've done your homework, you have take a lot of notes, and you're rested up. What you agree to in one session is not binding, or what you agree to in the second or third session. Those temporary or those interim discussed resolutions, nothing is binding until the memorandum is drawn up, the attorney has prepared the agreement, and the agreement is signed. So parties can change their mind or back out at any time. The hope of the mediation process is that there's buy-in, that nobody is just wasting time or playing games, but there's actual buy-in. A contested divorce, 12 to 18 months is what the courts are asking. Once a judge gets assigned to a case, the judge sets a timeline for when discovery has to be done, appraisals have to be done. Is there a business to value? Do we need an attorney to represent the children to resolve custody? And the judge is going to keep pulling the parties and the attorneys into court periodically. Some judges will pull you in every 60 days, some more, some less. But the judge, it's like putting a train on a track. It's got to hit each station at a scheduled time. Lawyers can play around with that a little bit, adjourn things a little bit, but once it's assigned to a judge, that judge is required to have the case resolved within a set time period. Uncomplicated divorces, meaning there's no like big businesses, appraisals, or big financial issues, I believe it's 12 months, and more complicated, 18 and maybe 24, you can get an extension. But that's a long time to be living in this land where you don't know what's going to happen with your life. Whereas if you're negotiating with a mediator, or again, if you're negotiating with your lawyers, you have more going on in the process, more of a hand on what's happening, and hopefully less anxiety. And the other reason I suggest you get an attorney through the mediation process is when you wake up with a question on your mind at 2 a.m, you can't call the mediator and ask. You can't call me and ask either, but you can send an email and you'll hear from me the next day, or your lawyer the next day. But it's all those little anxieties and details and things you forgot, because in the heat of negotiating, you forgot. You have someone there that you can call and inquire of, and have your anxieties resolved or addressed. Okay, the role of the mediator. This will just highlight some things we've already discussed, but to reinforce it, they are supposed to be a neutral third party. So some people say, I want a woman mediator, I want a man mediator. I don't care about the gender of the mediator. A good mediator, it doesn't matter. Their goal is going to be to bring two parties to an agreement. I describe it as understand the mediator does not care. And I'm not saying doesn't care and that he doesn't care for the parties or she doesn't care for the parties, but the mediator doesn't care if one party walks away with 90% of the assets and the other walks away with 10. The mediator's care and focus is that both parties agree and are satisfied with what they've agreed to. If one party is going to walk out with 90% and the other with 10%, that's on the parties, and that's where the parties need to be talking to an attorney so they don't wake up a week after they've signed an agreement and have a judgment of divorce and realize, I didn't know I was entitled to half the house. I didn't know I was entitled to a piece of the retirement. I didn't know I was entitled, she told me that money was inherited. I didn't know it wasn't inherited. I didn't know it was saved. So the mediator's goal is to get the parties to an agreement, not at any cost. They're not rushed up against the clock to get it done, but they're not there to say, hey, do you know you're getting a bad deal? So anyway, they're supposed to be neutral. And they should be trained and skilled in conflict resolution and have some training on personality types and psychological background, and know how to handle. You deal with a passive aggressive person differently than you do with someone who is obsessive compulsive. And we all have some of these traits in us. So anyway, they should have some of that background, and I would question a mediator on their experience when I interview them. Again, they don't represent either side in the settlement. They facilitate negotiations. As I said, they cannot give advice, but a good one will signal when to break and get some help. The focus is to help each party better understand and communicate their common interests. If we can find common ground, then we can resolve a few things up front, get a good rhythm going, and now let's talk about what we don't agree on and try and find something that connects us on those and some creative ways to resolve that. And I'm sorry, Brittany, I should have told you we are on the slide, the role of the mediator. My apologies. When common ground is found, or when the parties begin to see the basis of the other party's position, that's when the mediator is able to start moving them forward and look at some options. But The mediator's job is not to come up with the solutions. They will have some if they're experienced and good and say, have both of you thought about the possibility of neither one of you buying the house out right away, but one of you having exclusive occupancy for the next 2 years and blah, 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 blah. And some mediators are very good and will put some thoughts out there, but a lot of them will not, either because they don't have the knowledge or that's not their style. That's where consulting with your attorney in between the sessions gives you the tools to go in and say, all right, John, if you're not willing to buy me out of the house, how about we consider, or if you can't buy me out now, how about I hold a mortgage against the house and you pay me out over time? Don't count on the mediator coming up with all these suggestions. They may come up with some or none. The mediator looks for creative options, again, tailor-made, depends on the quality of the mediator, but they are not going to come up with all of them because some suggestions may go on the cusp of advocating. They see that the father really wants to keep the house and they see that the parties are close to getting somewhere, but making a certain suggestion may be an advocacy role that they can't go beyond. So don't count on the mediator being the one to come up with all the bag of tricks for you. They cannot, as I said, advise on the law. And in fact, they must not, because if they do, if that's happening, you need to put brakes on the mediation, talk to an attorney, because that's crossing over into advocacy. Role of the parties. As indicated, you are voluntary participants. At any time, either one can walk away either just to take a break and say, look, you know, we've made some progress, but I really don't want to do another session in a week. I need some time. Mentally, I need a break, or I need a break to get some information. I have a client right now. She and her husband have been in mediation for at least 1.5 years now. And that's unusual, but they want to take it very slow for whatever reason. And we stay in touch as to what's going on, but they want to take it very slow. As long as both parties are good with that, fine. But at any point, either party can say, this isn't getting anywhere, I don't want to do it anymore. Or, God forbid, something tragic erupts, like hypothetically, one of the parties gets picked up driving drunk with a kid in the car. All right. You probably need some immediate court intervention regarding protection of the child in custody at that point. So that may put the brakes on further mediation. It may squash further mediation, but you're not locked in. My point is you're not locked into it. Once started, you control. It's cooperative decision-making process. Disclosure, again, remember, it's good faith disclosure. Let me digress for a moment. Most people that talk with us about separation or divorce fall into one of two categories. And this is how I want you to distinguish litigation approach versus problem-solving approach if possible. I have some people that come to me and say, I need to know every dime in the marriage that exists, and I need a deal that puts 5 cents in each column. I need half of I want to know what everything is, and I need half of everything. And that may be their right. And New York State is equitable distribution law. That doesn't mean equal, but most of us know that unless there's some reason for a court to vary from it, a nickel's going to go in each column. If that's the process you need, it doesn't mean you can't use mediation, but mediation is more geared toward the person that says, look, I got a pretty good handle on what we have. We're W-2 wage earners. There's nothing hidden or buried in the backyard. I have a good handle on what we have, and here's my priorities. I want A, B, and C. I'm willing to negotiate everything else, look at creative ideas. That's the type that works very well in mediation because they have a good grasp on what there is and they know what their goals are, and they can work with their lawyer and the mediator to reach those goals. It doesn't mean you can't shift from one scenario to the other. I really don't need 5 cents of every dime, or I decided I really do need it. But understand that if you're doing the I need 5 cents of every dime approach, this disclosure process through mediation or even through negotiating with lawyers has its limitations. Because if somebody is hiding assets or not being honest about what they have, and it's not in joint name, so you can't get a hold of it, and you suspect they're hiding assets, nothing short of litigation is going to ensure that you get 5 cents of every dime. And even with litigation, there's still ways people hide money. But outside of actual litigation, suing a case, lawyers cannot serve subpoenas on banks to get records. Lawyers cannot serve discovery demands, which require parties to swear under oath that they are disclosing everything. Lawyers can't make motions to court for discovery or authorizations. Lawyers can't take depositions and dig into people's finances. And without cooperation of the parties, lawyers can't hire appraisers. If my husband has a business in his name, I can't just unilaterally hire an appraiser to go out and appraise the business. So understand those limitations. But open communication, open mind. Okay, completing mediation. So I want to leave some time for questions if there are any. Drafting and executing the agreement. When all issues are resolved, mediation is considered complete. The eventual agreement must meet all the valid and enforceable requirements of statute and the law. Again, do not sign a memorandum of understanding. I don't care if it's 20 pages. Have a lawyer look at it first to see if it meets all the requirements, and if it doesn't, have a full agreement drawn up. This is where people are paying us to redo work that was done previously, because this wasn't done right. Ensure that if it is not drafted by counsel, it is at least reviewed by counsel. Let me back up. I think even if the agreement is going to be drafted by an attorney, let's say the other side's attorney is going to draft the agreement, you should have the memorandum looked at before the agreement is drafted, because there may be obvious flaws in the memorandum that you want to have addressed before someone pays an attorney to draft an agreement, and now they have to go back and change things. Filing for the divorce. Understand you are not divorced until somebody actually files a complaint, submits all the necessary paperwork and the signed agreement to a judge, and then the judge signs off on the divorce. Why may you not want to get divorced right away? There are a few reasons why people may want to stay legally separated under the signed agreement and not divorce right away. One of the most common reasons is health insurance. Most insurance companies will continue to cover spouses until the actual judgment of divorce. So I did have a case years ago. My client had breast cancer, and I think she was treated for 6 or 7 years between treatment and reconstructive surgery. And they stayed legally separated till she got through all the surgery, treatment, and reconstruction. And then they got divorced. She needed his medical insurance. Tax reasons. Some people want to be able to file jointly at the end of a particular tax year. So if I have a client who signs a separation agreement in February this month, but they want to be able to file joint tax returns for 2025, they're going to have to stay married until the end of the year in order to do that. Some people, they have children and they want to take things slow. Psychologically for the kids, being legally separated may feel a little bit better than my parents are divorced. I don't know how much that floats these days, since it's much more common, but for the sake of the children, some people do it that way. And some people, I just got an email this morning from a gentleman. I did his separation agreement in 2004, and he's reaching, and so we're talking 20, almost 21 years later, he's saying, oh, we finally want to get the divorce. 20 years later. I suspect the reason he now wants to do it is there's probably a pension involved, and we need to make sure that he can get that pension split. And I will digress a minute here. If there is a pension involved, a pension, a 401k, a tax savings plan, any kind of tax deferred retirement account involved in your case, do not get anything finalized before you see an attorney, because the language that is required to address these pension division orders, these retirement orders, is so highly specific. It is governed in large part by federal statute, not state statute. And if the agreement isn't worded properly, the order can't be done properly. And you can find yourself having difficulty getting your share of a pension, or if it is your pension, you can find yourself losing more of your pension than you should be losing. It can tie things up for years. We have several cases with people coming back to us with agreements that were not done properly by other attorneys years ago, and we are spending oodles of time and money fixing it. So, like anything, get it done right the first time. Filing for divorce. Just to run down some of the things we already spoke about, you need the fully and properly executed agreement. The uncontested divorce documents, we call them 211s. It's just probably about 12 or 15 documents, depending on whether there are kids or not, that get completed. There is do-it-yourself packets with OCA online. They are a nightmare. They're so bad. I believe they're in the midst of reforming all those documents. My suggestion is if you like banging your head against a wall, try doing the forms yourself. Utilizing counsel, it's pretty swift, and if an agreement is already signed, not exorbitant to just get an attorney to do it for you the right way. Post-COVID, we are e-filing all this stuff. So divorces are happening in matters of weeks or months, as opposed to, I used to tell clients 4 to 6 months. Unless a judge is very, very busy, they're happening within weeks or 6 weeks. Who will be the plaintiff? It really doesn't matter. It's a no-fault divorce. So nobody's blaming anybody. Nobody has a black mark for being a defendant, and the records are sealed. So unless you share information with anybody, your neighborhood does not know. The plaintiff usually will bear the greater cost because they have to pay the filing fees to the clerk's office, and if they retain counsel, have to pay the attorney to do the papers. But again, it's not a heavy lift. Timing, cost and timing we've spoken about. Next slide, we'll recap and then we'll take questions. Again, I don't want to just hear myself talk, but the recap is we're talking about alternative dispute resolution. It's an excellent process, but not for all couples. Think about it. It is often, almost always, less costly than divorce litigation. It takes the mediator in the role of a facilitator and the parties as problem solvers, and it is not complete until all issues are resolved and a properly drafted agreement is signed. So I see we've got about 7 minutes left. If there are questions, I'd be more than happy to try to answer them.
Can somebody qualify for alimony with a marriage of 6 months?
There is a mathematical formula for determining spousal support. New York State came out with a few years back, and it compares the parties' incomes. So the first question is, are the parties' incomes disparate enough that the formula would result in a requirement for one party to pay the other support? And then the second piece is duration, which is what this question is about. I've only been married 6 months. How long would I get it for? The formula also has a durational formula, a calculation in it. If one were married for 6 months, the duration would be so incredibly short under the formula that I can't even do it right. Let's see, what do I have here? 6 months. It's 15 to 30% of the length of the marriage. So even if you got 30% of 6 months, the higher end, you're talking extremely short, a week, maybe 2. I can't do math quick in my head. However, if there are some real extraordinary reasons why support should be paid, like the person is like physically disabled and has no source of income and no work and no ability, you might be able to get a court to do something a bit longer. But if you've only been married 6 months, you can't even sue for divorce until you've been married at least 6 months. So bottom line, it's not going to be a strong claim unless there's something really extraordinary going on that a court would have to address.
Can you borrow from your TSP retirement to pay for the mediation? And can you borrow a pension while going through a divorce?
Okay, so can you borrow from your TPS in order to pay for the pension, pay for the mediation? Yes, because I'm presuming a lawsuit hasn't been commenced yet. You're going to mediation. You don't want a lawsuit yet. So until the lawsuit is commenced, either party is free to borrow money from their money market, their TSP, their 401k, their cousin, take it out of the checking account. There's no restrictions on assets unless and until an action is commenced or an agreement has been signed. If a divorce action has been commenced, there are automatic restraining orders that go into effect. And when a party serves or gets served with a summons for and complaint for divorce, those restraining orders are listed on the summons. And one of the restraints is that you cannot borrow or transfer assets outside the ordinary course of, paying your household bills and all that stuff, obviously. So, but with permission of the other side, the attorneys talk and come up with an arrangement that can be done, or you'd have to make a motion to the court to get permission to do it. So that's actually, the question is very good because it hits on the angle of one of the other reasons to stay away from litigation if you can, is because as soon as litigation starts, a complaint is sued, now there's all these restraining orders in place. On the one hand, it's good if you're looking to protect the assets because you think the other party is going to invade them, but you're also hamstringing yourself in your ability to access and use assets.
What happens if the other party is hiding money?
You got to find it. It's the answer. And that is another reason why, again, mediation may not be for a situation where somebody is worried that there's dishonesty and the pot being split is not the full pot, so to speak. The mediator and the lawyers have no authority to force anybody to honestly turn things over. You're acting in good faith. It is, if you think somebody's hiding money and it's significant enough to invest in litigation over, then once a lawsuit is started, attorneys can serve discovery demands, subpoenas, request authorizations, hold depositions, make motions, even hire financial forensic experts, which are financial people that will go through the records and find the missing money and trace the hemorrhaging. This is why it's really, even before mediation, I recommend a consultation with an attorney. Because while I recommend mediation 90% of the time, there is that 10% of the time after talking to the client, I say, look, the scenario you're describing to me, mediation, unless you trust this person, and from what you're telling me you don't, mediation isn't going to work. Now, am I just worried because there's, $50 a month missing from the bank account in the last 2 years? Is that worth litigating over? Or my husband used to have a 401k with, $180,000 in it. Now it's missing. Well, now that may be worth litigating over. So doing a cost benefit analysis is really what you need good advice for.
Can you have a mediation with an attorney representation? And would they be using a shared retainer fee? If so, what would that look like?
Oh, if your attorney is also a mediator?
Yes, like
No.
as if they are doing both for you.
No, because an attorney can't represent you and mediate with the other side. Because if you hire the person as an attorney, then they're your advocate, and that advocate can then not be neutral. So what you want to do is hire a neutral mediator, somebody you both have interviewed and both like, and then use your attorney to guide you on the sidelines. Sort of like a coach in between innings.
If there was abuse in the relationship, if it would still be a good idea to file a police report and get information disclosed to an attorney, or should that go to the mediator?
So if there's been domestic violence, just read that again because these questions are multiple. So I want to make sure I break them down. First part of the question?
If there is violence within the relationship, it would, with a filed police report, where should this information go? Should it go to the attorney or the mediator?
I think it should go to both, because some mediators have very strict rules on whether or not they will. I would start with your attorney, talk to your attorney first so they can kind of help gauge, is this, once he just said he was so mad at me, he could smash my head in and that was it. Or, she stabbed me, how severe is it? because there are a lot of police reports that don't escalate to seeking orders of protection. So I would discuss it with your attorney first. In all likelihood, the attorney will want you to disclose it to the mediator. Some mediators have certain standards that they follow, that if it's just a police report, they don't have a problem. If it escalated to an order of protection, they may not want to mediate. And because so much of it can be done via internet now, if you just have a stay away order, but the parties can still communicate, you may be able to do it over Zoom or something. But definitely talk to your attorney first, and in all likelihood, it should be disclosed. Thank you, everyone.